Good day to all our viewers and welcome back to another What If session with us here at Maserumule. My name is Viepie and today's topic is what if an employer dismisses an employee for misconduct whilst knowing that the employee is suffering from a mental condition? Is the dismissal automatically unfair? In other words, you have a situation where your employee commits misconduct, but you as the employer knows that at the time when the misconduct was committed, that employee was suffering from a mental condition. The question is, if you've dismissed that employee, whether such a dismissal can be seen as being automatically unfair. Now, to answer this question, I will be unpacking the recent Labour Appeal Court decision in the matter between Legal Aid South Africa versus Mr. Jansen. But before we discuss the facts of the case, let us briefly look at what is an automatically unfair dismissal with specific reference to this matter. Now, Section 187 of the LRA states that a dismissal is automatically unfair if the employer, in dismissing the employee, acts contrary to Section 5, or if the reason for the dismissal is because of or based on certain grounds listed in the Act. The second part of the definition is applicable to our or to this specific discussion. In other words, is the reason for the dismissal relating to something listed in the Act? An employee's pregnancy, for example. An employee made a disclosure and the reason for the dismissal is because the employee made a protected disclosure, etc. But with reference to this case, the court had to determine whether the reason for the dismissal of Mr. Jansen was that the employer unfairly discriminated against him based on his mental condition. Now, in our law, it's trite that in determining whether a dismissal is automatically unfair, an inquiry into its causation must be undertaken. That entails two things. Firstly, factual causation must be established, and secondly, legal causation must be established. Now, factual causation, ladies and gentlemen, would be established by asking whether the dismissal would have occurred had the employee not suffered from a mental condition. If the answer to this is yes, you would agree with me that the dismissal is not automatically unfair. Right? In other words, the dismissal would have occurred irrespective of the mental condition. If the answer, however, is no, in other words, the dismissal would not have occurred had the employee not suffered from the mental condition, it does not mean that the dismissal is automatically unfair, because we need to also establish legal causation. Now, when is legal causation established? Legal causation is established where the reason for the dismissal was the main, the dominant, the proximate, or the most likely cause of the dismissal. Now, applying that to the set of facts, just briefly, the summary of the facts of this case was that Mr. Jansen was charged and dismissed for absenteeism, gross insolence, and refusing to obey a lawful and reasonable instruction. It was common cause that Mr. Jansen, at the time of his dismissal, at the time when the misconduct was committed, was suffering from manic depression. So he challenged his dismissal before the Labour Court, claiming an automatically unfair dismissal in terms of Section 187, subsection 1F of the Labour Relations Act. Mr. Jansen contended that in his view, the true reason for his dismissal was not his misconduct, but rather his manic depression. So the matter was heard by the Labour Court, and in summary, the court held the following: that Legal Aid, the employer, would not have dismissed Mr. Jansen had he not suffered from his condition, and that his conduct was the basis for his dismissal, which was intimately linked to his mental condition and not the absenteeism, insolence, or insubordination complained of. Accordingly, the court held that Jansen was unfairly discriminated against on the ground of disability, and it was held that the dismissal was accordingly automatically unfair. I believe the court reinstated Mr. Jansen with full back pay, and over above that also awarded him 6 months compensation. Legal Aid was not happy with this judgment, and they took the matter on appeal. And that is what we are discussing now, the decision by the Labour Appeal Courts. Now, in summary, the Labour Appeal Court held the following: In order for an employee like Janssen to succeed in an automatically unfair dismissal claim based on depression, the inquiry was not confined to whether he was depressed and whether his depression impacted on his cognitive and cognitive capacity, or whether it diminished his blameworthiness. This was something that the Labour Court latched onto. The Labour Appeal Court said instead, the determination or the inquiry is directed at a narrow determination of whether the reason for the dismissal was his depression and if he was subjected to different treatment on that basis. The court found that the employer legal aid had a legitimate basis for imposing discipline, notwithstanding Janssen's depression. And as a result, the proximate reason for disciplining Janssen was solely due to his misconduct and not the fact that he was depressed, as he was relatively capable and knowingly conducted himself in contravention of the rules of the workplace. In other words, ladies and gentlemen, factual causation might have been established, but legal causation was not established, because the proximate reason, the dominant reason for disciplining or eventually dismissing Mr. Janssen was solely due to his misconduct, not the fact that he is suffering from a mental condition. So the court concluded that the mere fact that Janssen's depression was a contributing factual cause was not a sufficient ground upon which to find that there was an adequate causal link between his depression and his dismissal, and to then conclude that the depression was the reason for it. The court then held that the dismissal of Mr. Janssen was not automatically unfair. Now, ladies and gentlemen, the court made a comment on this to say that although they have made the finding that the dismissal is not automatically unfair, it is not to say that the depression of an employee is of insignificant relevance. Depression is, we know, a prevalent illness in the current environment, and there's a duty on employers to deal with the depression sympathetically, and employers should investigate the depression fully, as well as consider reasonable accommodation as well as alternative short of dismissal. In addition to this, the court held that where depression may account in part for an employee's misconduct, depending on the circumstances as well as the nature of the misconduct, dismissal may not always be appropriate. But in this case, and as what the court explained, in this specific instance, there was no proper claim of substantive unfairness before the Labour Court. Now, we have heard that this matter is set to go on appeal to the Constitutional Court, and it will be very interesting to see what our Constitutional Court decides in this case. However, for the time being, we are guided by the judgment of the Labour Appeal Court. Ladies and gentlemen, for any advice in this regard, as always, please do not hesitate to contact us. Our details can be found on our Facebook page. We will highly or really appreciate it if you go ahead and like our Facebook page. And again, thank you for joining us. Until next time, goodbye.